Hello, everyone. Thanks for joining us today. My name is Hamid Kohan. I'm the CEO and founder of LegalSoft and also lawpractice.ai. The topic today is about how to scale any kind of a law practice with the given challenges and opportunities that has arisen in the past 12 months or so. There's been a lot of changes, especially in California and AI, and I wanted to take this opportunity to express what our understanding and our recommendation is to be able to scale a law practice in given today's conditions. So there's a few challenges, especially for California personal injury attorneys, that includes first of all, the most sensitive thing is the Uber back initiative that limits the attorney's fees and the physician's fees in any case of a personal injury accidents that is on the ballot for the November. And that's going to make a major impact if it passes. And it's going to impact the PI practices in California dramatically. So a lot of the personal injury firms are looking into opportunities to either pivot or expand or scale in a different ways to protect the firm from the impact if this initiative passes. And from the looks of it, already it looks like it has a very good chance of passing, unfortunately, because the way it was written, it is very consumer friendly and is not it doesn't create any kind of obstacles for them to be able to gain more of the settlement fees than they do today. The next one is the AI. I'm sure everybody's bombarded with hundreds of different AI initiatives, from AI, from intake, drafting, document collections, case summaries, litigation support, pre-lit support. It is getting very, very crowded. Even for folks like us who are into AI, and we have our own AI initiative, AI company, and so forth. When you go to one of these conferences or you go online, there's like 500 solutions daily and adds 100 every day to it. So how do we use that? How do we use that for scaling? And how do we find the right ones to use? So that's another challenge. The cost of client acquisition is on the rise dramatically. Some of the examples of the cost of client acquisition increases. In the past 5 years, the cost of client acquisition for personal injury in California has gone up from $1,200 per retainer to upward of $6,000 per retainer. So it's almost 5x. And how do we deal with that? A lot of big firms are in there spending millions of dollars a month. It increases the cost of acquisitions and all the new firms coming in, even the big firms like Morgan & Morgans and so forth. They're just spending tremendous amount of money, especially on Meta, which raises the cost for everybody else. Increased costs of labor, overhead, technologies, staff, local staff. That also is on the rise, which reduces the gross margins and ROIs and EBITDAs and everything. So these are the four major impact that I see with the legal industry, especially in California. So what do we do to actually, handle this and use it to the benefit of the firm and not be essentially the victim of all of these negatively impacting changes? So the next, there's several solutions that we recommend. Haley, next, please. That we recommend to be able to handle these changes. One is to pivoting the firm into different practices. A lot of firms, and again in California, have been practicing PI for 20, 30, 40 years, and it's been pretty consistent. Now with the changes, it could impact, and you got to get ready. What do we do next? What type of a practice? What are your preferences? What's the most feasible, affordable practice to pivot to, which will explain some of the samples of the practice types that we have experienced in, that we've seen very good results from pivoting firms, and the kind of a practice they've gone into, and what does it take to actually get into those practices. The second part is the reducing the cost of the operation. So there is two ways currently on the table to reduce that. One is using more AI and technology, but department by department, not the whole sort of a practice going AI. That's the ultimate target, but I think it will be some time before that actually happens. And also virtual staffing, which is what LegalSoft specializes in. We have currently firms who have converted extensively their local staff to virtual staff, upward of 80 to 100 virtual legal staff into the law firms from intake all the way to litigation. So we can discuss about that. Um, One of the attractive expansions that a lot of the firms already been doing it, and we've been involved in a lot of those expansions, is to be able to expand the practice outside of California to other states. So the challenges comes, what state? What does it take to set up? What's the bar requirements? Everything like that, so we can discuss how to select the right estate, how to set it up, and how to make it profitable. And we done, at least in the past 2 years, 50 plus those initiatives where we help the firms to expand into those estates. And the last, which is something very brand new, uh, the private equity industry and ventures been trying very hard for past many years to get into legal industry, like they gone into dental, medical, accounting, and so forth, where they want to basically be an investor and play in the legal industry. Because of all the ABA requirement, they haven't been able to, because they need to be licensed. You can't operate or have any kind of a fee arrangements with the firm if you're a non-lawyer. There's the ABS program that has happened. There's a variety of different things, but now they're in. They actually found a way that is completely compliant with the state and the federal law to be able to benefit from investing into a legal industry and multiple firms. And it's called the MSO, it's Managed Services Operation. They were figure out the formula, and we'll talk about that a bit, but you welcome to research it also on your own and find out what's the details of doing the MSO. Next. So the practice type. What are the best practice types that the most people are now sort of looking into? And we've seen what works and what doesn't work. Like, for example, if you go from a personal injury or employment or labor into mass tort, that's not quite works. It's a very, very specialized environment, operations, lawyering, everything is different. So one of the most likely practice types that we have migrated a lot of firms into from PI is been employment. My employment firm clients not going to like this because it's going to create, I already got a lot of calls about this, that what are you doing? You're bringing a lot of PIs into employment, and that's going to make it a challenge for us. No matter what I do, what I say, the trend is this anyway, and it's happening. So I'm sorry about that on the employment side, but the PI firms are pivoting into employment. It is a lot more difficult than is preserved to be, because employment is not like PI. It has multiple angles. So if anybody doing the employment firm, they have to structure it very differently. I recommend a lot of them that they want to start and do this, start with referring and referring them out instead of doing it themselves, to get the lay of the land as far as what does it take to create the employment cases. And then once they create it, what type it is. It's not like a personal injury that somebody got rear-ended, doesn't matter how, where, who. In employment, matters a lot, because you have so many different categories of employment where the firm is specialized on. For example, wage and hour, very, very sort of a level of employment cases where some firms take it, some firms don't, even though they're employment firm. Then you got a single action, which is usually some type of a termination and discrimination. Your pregnancy discrimination and sexual harassment cases, they're very hot, but obviously harder to get and harder to litigate and monetize. Then the next level is a class action employment, which has got its own sort of a challenges, being a part of a PAGA, which PAGA changes a lot. And the arbitration agreements have made a big dent into the PAGA requirements and being able to classify the case as a class. So you got wage and hour, you have FIA, which is all the terminations, wrongful termination and discrimination, and then you got class action. And they operate very, very differently from one another. So being able to navigate that, my recommendation is to start generating the cases because you really can't lose on that, and you can refer them to the employment firms. And we can help you with that because we have hundreds of employment firms in our network. And then you find out what does it take, what does it take to do the intake, retain them, qualify them, and you can sort of watch employment firms do this to learn from it, and then you can start your own employment firm. Otherwise, it might be a little challenging to just jump in there. Then you got consumer protection. Consumer protection runs anything from lemon law, which has been very hot in California for past 5-6 years. It's taking its toll. It's not as hot or profitable that it used to be. But there are other consumer protections. There is like a TCPA, a telecommunication protocol, which is a federal, which means you can take cases in the multiple states. Then there is Social Security disability and a few other consumer protections where you can practice on. It's much easier to set up, obviously, and practice or refer than employment labor would be, but that's another good pivot. Administrative law is a lot of different practices that is, again, SSI is one of those, the release and compromise, which is a federal tax practice type. Those are also administrative law that folks can pivot to. Now, the next thing about being able to basically expand into other states. A lot of people traditionally think of the bar exam. I need to go to Arizona, Texas, Colorado, whatever, take the bar. I don't want to take a bar. It was 40 years ago when I took a bar, and everything else and stuff is been there for a long time, but very few people take advantage of that. Because it's going to tedious. You got to stop your life, your practice, and so forth. Go get ready for it, and take the bar and wait for the results. So that's been a traditional. The new way that we came across about 7-8 years ago was called a UBE state, a Universal Bar Exam. So Universal Bar Exam is sort of a combination of, right now is about 39 states. It used to be about 27 that basically agreed to be in the pack where they honor each other's bar exams and the people who pass the bar in that state. And once they do that, they are eligible to apply for other states and just doing a background check and application fee and the compliance part. They don't have to take any bar exams or anything like that, and they get fully integrated into the state bar. So they almost like they're living there, pass the bar, and practicing. So, and you can do as many states as you want out of the 39. Obviously, California is not in there. California always runs its own thing very differently than everybody else. But the most of the state, which is 35, 39 plus states, honor that program. And you can be, I have an attorney right now that is like 33 years old, and he's licensed into 8 states already. Because every 2-3 months, he applies for different states and he just gets accepted because his score from where he resides in Arizona was very good. So he's basically in there. Now he can take cases in 6-7 different states. So it's not difficult to do. And then you have the also traditional admissions, which is per case, per event, a situation like that, which I do not recommend. And I would explain on the UBE how easy it is to actually get somebody local to go take one of these tests. It could be Arizona, it could even be Hawaii or Alaska if you want to. I actually sent the attorney to Alaska for about 5 days. He went there, studied 5 days, passed the test, came back, and is a UBE state. Not that he wanted to do anything in Alaska, but it was convenient, and now he can basically be admitted in a lot of different states. So that's the multi-state practice type. that we can even do a complete turnkey setup for those estates once you're there, because you don't really need to have a staff in there. Virtual staff can do everything, and everything in your local office can happen. You're just able to sign a retainer in that state and advertise in that state. And we've done a lot of those. So that's another category. The practice setups in these estates for the multi-estates, Haley, next, please, is the practice setup that we basically setting up the whole turnkey operation for that practice. So let's say you're setting up a practice in Texas. Is to help them to get online presence, do all the interactions between referral attorneys, doctors on liens, and the business license setup, the AI implementation. Is a complete turning situation where you can basically do this in 60 days or less and be completely present in the state that you wanted to start the practice. So once you get your UBE, the next thing is like, okay, let me set up the practice, and it is really for us, it's pretty turnkey to be able to set up, and even the lead generation companies or advertising companies, we know them, we know how to set it up, and we just set it up for you as a turnkey, and now you're practicing in 2-3 different states. So the federal law practices, which is, you can call it administrative law or federal jurisdiction laws and so forth. These are some of them that we talked about. The TCPA is getting very popular, especially with all the calling and texting that is happening without permission. So that's a very, very growing industry. Compromise and release been around for a while. Now that essentially IRS is in the collection mode, there's a lot more clients in the compromise and release market. SSDI, we talked about. Also, VSSDI, which is Veterans Program and the Veterans Benefit. These are all corporate, high-volume practice types. There is hardly any litigation whatsoever. It's like at the most, they basically write the appeal for the decision, and they do one Zoom appearance, court appearance, and that's it. I haven't seen anything. The only exception has been on the TCPA, but TCPA can also be a class action, and it goes into litigation, but it's less than 5% of cases becoming a class action TCPA. But these are some samples. I'm sure you guys can find another 6 or 7, and it's the federal jurisdictions with a high volume. The thing about what makes this unique is usually high volume. Obviously, the fees are capped or averaged out, but it does a minimum lawyering and high productions. So you have to be very lean and mean operations with very strong intake, bilingual intake team, and then very streamlined process to do the document collection, document summary, some drafting, and just schedule an appearance or deposition, and you're set to go. The next thing you know, you're just basically sending out the demand. Or in these other cases, like in the SSDI, when the case is overturned or appeal is approved, they get anywhere from $7,800 to $9,300 attorney's fees. Is capped, but again, it's a high production environment. So that's what makes it sort of interesting and long term. So basically, we're able to have a conversation either as a group or individuals for folks who are interested and want to have a different conversations and ask different questions about any type of a topic we talked about, either setting up, multi-estate, doing AI implementation for your firm, or virtual staffing or anything like that. We have a lot of data. We work with about 1,000 law firms, and so we have a lot of insight into how the law firms operate, what the market is like, what's the cost of client acquisition. We pretty much know exactly the cost of client acquisition in every estate on multiple practice type, being a PI or employment or other practices. And what does it take to set up a streamline? So I'm going to open it up for questions at this point. And please, again, you can scan and set up your own appointment. Haley, why don't you put that scanner QR code back on so they can have it, and we can start taking some questions. So Dan has a question. Haley, can you read the questions? Because I can't see the questions.
Yep, in order for me to read them, I just have to stop sharing, so I'll bring that back up.
Okay.
Give me one moment. Okay, I'm actually allowing Sasunas, who has his hand raised.
Okay. You can basically allow everybody who has a question to go and ask. Go ahead, please.
Sasunas, I think you're on mute.
You want to move on to the next person?
Sure, let's do Emrani.
Or for some reason, when they go, they get muted. I think you need to unmute everybody.
Yep, I have talking permitted for both of you if you, oh, he just dropped off. Okay, so I don't see anybody else with their hand raised at the moment. If you guys want to also drop any chat messages, you can feel free to do that and Hamid can answer them. Okay, looks like no current questions. Is there any closing thoughts, Hamid, that you would like to end with? And I'll make sure we have this up.
I think the best thing is to have a QR code up, and the folks who have a question or they want to have a consultation or anything like that, they can basically schedule in a time where we can talk specifically about your interest or your request and go from there. And how much? Okay, so they started showing up some. Okay, so how much initial seed money should have someone to start? Well, it depends to the practice type. Like when we talked about the administrative or the federal, it's much lower because you don't need a lot of people or a lot of systems, and we can even set you up to get case referrals or doing it yourself. So it's a minimum amount. I would say less than 100K will be fine. But if you're going into employment or other practice areas, the investment is much higher and much longer term of return because it takes 2+ years for any kind of a ROI on the case. On some of the cases, you can look at a 6 to 9 months return on the investment. Where are highest valued employment cases actually coming from right now? Believe it or not, most of it is from Meta, uh, which is the Instagram, Facebook, and so forth. There are some from the Google searches or AI searches, but they're a lot more expensive and to come and a lot less volume. So I would say Meta would be your highest bet. Why are we losing the rest? Um, Essentially because of the employment firms getting more picky about the type of a case that they take. So they are dropping or not qualifying all the intakes to be able to retain the client. Um, are we qualifying leads fast enough? No, this is one of the issues about the firms where they're getting the case. I've seen anywhere from 2 days to 10 days on the employment cases to be qualified by the firm to sign up. And that's way too long because after like 24 to 48 hours, the client is calling 5 other law firms. So if you're doing this, you got to do it pretty quickly. So it says, so we do not overwhelm ourselves. Which practice type do you recommend to start? Uh, Honestly, it depends to your long-term goal. If you at some point you want to do a lot more lawyering and litigation and so forth, I will pick employment because it's sort of endless from that point of view. And that can also be multi-states. And we know which states are equivalent to California. Essentially, they need to be a blue state and liberal to be able to expand out of. But employment is if you really want to do more lawyering litigations, and those administrative law or consumer protections are a lot less lawyering and a lot less investment. So to not overwhelm yourself, you have to pick if you're going to do more lawyering or not. And that would how you start your practice. Encourage people to get in contact with us, and we'll be able to help out more of you and how you can scale your firm and expand it out of California. Again, thank you everyone for joining us, and we'll keep everybody posted.